So we are recording. Thank you, welcome. We are on our third Q&A training session. Thank you for joining us and thank you for helping us get the word out. Judge Diaz is here to help co-host and I appreciate that so much. And also share insight from the mock trial that she presided over today, as well as share insight from the remote hearings that she's been presiding over for the last 2 weeks. So I do have a quick outline that I wanted to go through just so we all have the same base of knowledge. Obviously, y'all know that the Zoom app is there. You're able to get a free account or a paid account. Please share that information with your clients. If they opt to only get the free account, that will not preclude them from participating in a hearing. All of the Texas judges, Bexar County and the entire 254 counties, were provided a premium account. So when they call the hearing, when they call the docket, when they invite you to their meeting, it is on their account. And so even if you or your clients have the free account, you won't be timed out. You will accept the invitation from the judge. And even with the free account, you can participate in a hearing that lasts 40 minutes or a hearing that lasts 4 hours. That time is on the host of the meeting, which will be the judge. There is a chat feature. Those of you who have already started using it, you can see it. I don't know what the capability is if you're calling in on the 1-800 number to see the chat. I don't know, and Ms. Gavito and the attorney from Texas Rio Grande Legal Aid, can you see the chat that's been running since we started on this meeting, since y'all called in?
This is Letty. Yes, I can.
Okay, wonderful. So that's there. You can post questions to everyone, or you can select someone who is participating in the hearing or the meeting. Right now we have 40 participants. You can pose a question or make a comment privately to one particular person. Just make sure, however, that when you're doing this, you know what you're doing, as far as if you want the message to be to everyone or if you wanted the message to be private. There are going to be, as we continue to do these remote hearings, admonishments from the particular court that you are appearing in front of. Make sure you're not private messaging the judge during a hearing if you haven't been explicitly invited to do so, because that is tantamount to an ex parte communication. And it could be something innocent, it could be nefarious, but the expectation is that it would be innocent, but it would still be the equivalent of ex parte. So make sure that you know how you're using the chat function. You're slipping notes to your client. Obviously, don't private message witnesses that are testifying. Don't private message the judge. Understand that chats are not part of the record. And I think most judges are taking the position that they're not going to record the chats. They're not going to save the chats. And even as a host of this meeting, if you private message each other, I can't see it. I can't record it. So if there's something that happens, scenario, if opposing counsels use the private chat to curse each other out, I won't know. I won't see it, and it won't record even if I were to save the chat, because it only saves the chats that are to everyone and the chats that were sent to me as the host. It doesn't save chats that are sent privately outside of my presence virtually. So know that that's there, know the limitations. Don't use it if you should be saying something on the record. So for example, during a hearing, if one counsel refers to an exhibit as defendants one, but it was admitted as plaintiffs one, don't use the chat to say, hey, you meant to say plaintiffs one, because that's not captured on the record, and that's not going to be corrected on the record if all you're doing is putting it on the chat. Waiting rooms, all of you entered into the hearing in the waiting room. I think most judges are going to set up their hearings that way. Today, at today's hearing, I had 3 attorneys, an amicus, counsel for mom, counsel for dad. My practice was to let the attorneys into the room first, keep the clients waiting. We had one of the clients get on the call on time. We had another client that was about 10 minutes late. So rather than have one client come into the hearing before the other, I kept them out in the waiting room until I could let everybody in at the same time. I don't know if that's going to be the practice going forward. I don't know what we're going to do if they're too late, right? We don't want to hold up the hearing because folks aren't getting on the call and following the advice of their attorney. But that's something to be mindful of. And Judge Diaz, feel free to stop me. I'm trying to cover all of this to get to the questions, but if there's something that needs to be added, please feel free to interrupt and add.
Have I ever hesitated to interrupt you?
That's true. That's true. All right. And there's questions, please. If there are questions that come up as I'm trying to get through just the basic information, feel free to ask questions because I really want to make sure that this is as helpful as it possibly can be for everyone. So please, when you're preparing your clients for this type of virtual hearing, make sure that they know when they click on the link that they're going to go to a waiting room. There has been some delay because folks click on the link, they aren't let into the hearing right away, and then they just disconnect because they think that they did something wrong or the link's not working. So prepare them ahead of time that when they click on the link, they may just be looking at a screen that says, you are in the waiting room for Judge so-and-so, or you are in the waiting room, please stand by, and let them know that disconnecting may delay the hearing. Breakout rooms are a function that the host can create breakout rooms if, and this happened during the mock hearing, if you need to confer with your client or if you and opposing counsel, because of whatever testimony has come up during the virtual hearing, want to have a conference, that is something that can be done virtually with the host. You can ask the court for permission to confer and to be sent out into a breakout room. And the breakout room will be a space, a virtual room, just for you and whoever is put into that room. So know that that is an option. Different judges are going to have different practices regarding the breakout rooms. For example, and I forgot to give credit where credit is due. I have been taking training sessions from Judges Virial, Judge Ferguson, and Judge Mitchell, and obviously watching our local judiciary preside over their mock trials. So all of this information is gleaned from watching others, and I know Judge Miskell and Judge Ferguson did their training and it's posted. It was for the family law section, and I believe it's posted on Judge Miskell's YouTube channel. But you'll see when you start finding these training sessions that the judges are going to have, just as they do in the live courtrooms, they're going to have their own practices that are particular to that particular court. And so I say that by way of introduction. Judge Ferguson is taking the position that he's not ever going to enter into a breakout room. That's just for conference. He has no business in those breakout rooms. Other judges, myself included, I might use it for the equivalent of a chambers conference, for example. And I may go to a breakout room with opposing counsel or with the two attorneys and leave my court reporter in the main hearing and put the clients back in the waiting room. You know, so there's different configurations that can happen, but what we are really trying to do is make sure that this virtual courtroom can mirror the live courtroom as much as possible. So appreciate that that's what the judiciary is trying to do. The video placement, again, this is just aesthetics. You know now that there's a speaker view, that there's a gallery view. If you're on a laptop, if you go to the upper right-hand corner of the black box, you can elect which view you want. If someone's sharing the screen, that document is going to be front and center, and all of the little gallery views, everybody who's in the meeting will be off to the side or be up on top. There is an option, I don't know if you found it yet or not, to touch up your appearance. So if you go to the video, you can go to video settings, and that will give you an opportunity to touch up your appearance, to mirror your video, so that way you can switch it 90 degrees, rotate it 90 degrees if that's helpful for you. There's also the virtual backgrounds. Appreciate that this is inviting a new line of questioning, right? Where the witnesses are at. If they're using a virtual background, take it off. Let me see what your room actually looks like. Yes, and then pay attention to the placement of your video, right? We had during one of the hearings, this is informal, right? It's new. One of the attorneys just walked out and, I don't know, got something to drink and then came back. And it looks a little funny, right? To just see somebody in the window and then all of a sudden they disappear and it's a hearing and then they come back. So being mindful of that, share that mindfulness with your clients, right? If they're on mute, but they're arguing with their significant other or they're yelling at their kids, you can still see them. So please, share the new virtual courtroom and what you can see with them. The environment noise, I see that everyone is on mute, and that's helpful, right? I think when you don't mute yourself and you're not talking and you're letting the background noise come in, somebody had a meme that on Zoom, not putting the mute on when you're not talking is the equivalent of replying all, right? Like you're just letting everybody know your business of what's happening in your room, and it's a hearing and we're trying to listen to each other. And of course, our court reporters are doing so much work to get up to speed and, getting zero counseling headphones to the extent that Amazon will still deliver those and they're not on back order. I mean, they're really trying hard to make sure that you still get the record that you're entitled to, right, in a court proceeding. So make it easy for them and make it easy for the other litigants that are in the hearing, and just mute yourself if you're not presenting. Obviously, if you are the attorney that's going to be directing or cross-examining the witness, you may not want to have your mute on because you may want to be able to object without the hesitation. I understand that. But again, be mindful of what background noise is, including the vibration of a cell phone. If it's sitting next to your desk and it's sitting next to the microphone on your computer, it will come out very loud. So just know that that's part of our new environment. Let's see. What else? Okay, new lines of questioning will be developed based on this platform. So know that your clients may be questioned about where they are, who's with them, what are they looking at, what's in their lap. Adjust your video so I can see what's on your desk or what your hands are doing. And I've seen those questions already. They haven't been combative. They have seemed a little odd, to be honest, but it's part of this new space. And what I've seen thus far hasn't been so intrusive that it's inappropriate, but it is different enough that you may want to alert your clients that they may be asked about that. Something that's come up that Judge Miskell shared is that during one of her hearings, one of the client and the attorney were together in a conference room. Either there was a technology issue or there was a device issue, but the attorney and the client were together in the same space, sharing the same box. For whatever reason, the Zoom microphone had a hard time picking up two different voices from one box. And so during the question and answer during that presentation, only half of it was coming through because there was such a significant delay in picking up the other voice associated with the same box. So then they tried, I think the attorney lent the client the cell phone, and so they were both in the same room, two devices, and then you started getting this feedback. So it finally worked that it was two devices, two rooms, and they were able to proceed with the hearing. So know that may be an issue. If you want to accommodate your client, have them come to your office, that's fine. But know that may be an issue. And so, Ms. Guerra, we have our court's going to have access to pleadings. So different courts are going to be doing different things. I have requested in the remote hearings that we've done, I've requested the attorney be prepared to email me their live pleadings. So have it in a PDF that you can email. There are some attorneys, and Judge Diaz, I'm gonna give you the floor so you can discuss how you're doing it, are doing it different ways.
Sure. So today, for the first time in our mock trial, I tested the use of a Google Drive, which I think is how I will proceed in the future. Prior to this, with the protective order hearings that I've had so far, I've asked the parties to email me in advance all pleadings and proposed orders. I foresee, we know that there's going to be some cases where just the volume of documents is not going to be feasible to attach in an email. So for that reason, I think that we will all as judges have to be equipped with an alternative to receiving pleadings via email, perhaps through a shared drive. So Dropbox or Google Drive. Right now, because we're operating under a skeleton crew, we don't all have our clerks that we normally would reach out to. We each previously had our own designated clerks who we could say, hey, pull up this pleading and send it to me or print it for me if you guys didn't have it. We're not equipped, we're not there right now. So my best advice for all of you is, because you don't know who you're gonna be assigned to in advance, and everyone may be doing things a little differently right now, is to prepare all of your pleadings, your proposed orders, confer with opposing counsel and see how many exhibits you can agree on in advance and include those as well. Put those together in a compressed zip drive perhaps, and just have it ready to go, ready to either be emailed if that's feasible, if that's what the judge wants, or upon receipt of the Google or Dropbox link from your judge, you can just easily drop it in there. So the way this is working is presiding is assigning us cases by email. And then once we get those assignments, the assignment includes the contact information for the parties. And so the judge will then email the parties how their request for how they want to receive evidence. So they'll email you saying, this is the Zoom, they'll set up the Zoom conference, send you the credentials, and then also ask you to either email the documents or drop them in a link to a drive.
And just to clarify, by parties, we're talking about the attorneys. So I think the expectation is that we will send you the invite, you will have the credentials to come into the hearing, and then you forward that on to your client or your witnesses or whomever it is that you've got on standby so they know how to get to the hearing. I think it would be almost impossible for us to try to juggle collecting all of your witnesses, collecting all of the emails, and sending out the credentials. So we send out the credentials to the attorneys of record, and then y'all disseminate as you need to. And Ms. Irie, you raised your hand. You have a question? Come on. Let me unmute you. Oh, there you go. Thanks.
Sorry.
I'm like, come on.
I just heard that presiding is, I guess, submitting our cases to y'all or the courts through email, and then you're going to, the individual court is going to email each attorney. So is that just what we wait for an email if we're assigned to a presiding docket, or is there also going to be a way that we're watching presiding and assignment?
You're going to get an email from the judge who has assigned your case. That doesn't prevent you from watching the docket called on YouTube and seeing where you are in the queue, or just seeing how it works. You know, everyone's invited to watch the docket call on Monday morning. But when you get assigned, that judge that's going to be presiding over your particular case is going to send you the email with the identifying hearing room, if you will, with the credentials to get into the hearing room.
Thank
you. And I'm going to try to do this just so we can cover it. The share screen function, as the mock trials have progressed, and you'll see the difference once we get these training videos up, how much more proficient the attorneys are getting at sharing their screen. And it makes a world of difference on your presentation if you can share the screen and share the exhibits as you are arguing from them or as you are questioning the witnesses from them. And so, let's see. So practice with that as you with each other or on your own. I don't know how you could do it on your own, to be quite honest. But, get on Zoom meetings or Zoom conferences, do it during a Zoom chat with one of your colleagues, and practice sharing the outline or sharing your screen so you can present your evidence. Judge Diaz, there you go. Yes. So be wary that when you share your exhibits, if it's a function that hasn't been disabled, others in the conference, whether it be opposing counsel, an opposing witness, or someone who has found the credentials and just come in to be a spectator from their bedroom, they can annotate your exhibit as soon as you share your screen. So know that that's there and be mindful to watch out for that. But that's how you could share your screen, and you stop the share screen up on top. There's a red button. You just stop the share screen and then you come back. Let's see, we've got more chats.
And then just to follow up on that, that annotation can be obviously very helpful for you as you're presenting your evidence. But when you go to share your screen, there's a drop down at the top, I think, that allows you to select whether you want participants to be able to annotate your screen or not. So please make sure that if you don't want people to annotate it, and if you yourself don't need to use that feature, that you turn off the annotation function before sharing your screen.
Okay, and we've got a couple of questions. Ms. Hesbrook, if additional people want to join the meeting, are they like now? I don't see anyone in my waiting room now, but we are up to 41 participants. So I'm not sure if I've let them in or not. I will let you know just from the host perspective, and your judges will be the host of your meeting or your hearings. When people are coming in, and if it's at the moment that an objection is being argued, or if it's at a moment that the judge is making a ruling, it's going to be a learning curve for us to multitask and bring people in and talk and look at the shared screen and make our notes. So if there is someone that you're expecting as a litigant, if you've gotten a text message from a witness, from a CPS witness or a police officer or somebody saying, hey, I'm here, but I'm in the waiting room, and like they're the witness that we're waiting on to be called, don't be shy about letting the judge know, hey judge, I think witness so-and-so is in the waiting room. Do you see them yet? Or something like that. As a host, we do get a ding. But again, if people are talking and things are happening, sometimes it's not easy to hear. And
Judge Alvarez, may I add something?
Yes.
Sorry. A couple of things. One is that Mark Unger was suggesting, and I think it's a great idea for y'all to maybe start familiarizing yourself with how to do this. He's suggesting that rather than just emailing everything, dumping it, one folder with everything in there, that you create a Word document or a PDF that links to the pleadings and the agreed upon evidence, proposed orders, so that the judges, as you're referring to, and for everyone involved, as you're referring to an exhibit or something, rather than looking through this dump of things you've sent us, we can go to this one document and click on a hyperlink that will take us to that exhibit. I know Mark knows how to do it. I've asked him to work with me to get some instructions for others. I think that would be a really helpful way to get us information. And then I know somebody asked if all the judges can get on the same page about what we're going to be doing. We do have to be a little flexible because I'd love to say we could all do Dropbox or Google Drive, but we have to be able to accommodate folks that don't know how to do it that way, or don't have the technology to do that. So right now it is a court by court basis, but I think that Judge Alvarado and myself, correct me if I'm wrong, Judge Alvarez, but I think she and I are the only ones that have started testing the Google Drive. That's what I'm familiar with, and we can certainly bring it up at our judges meeting to encourage us to have some uniformity, but we do need to have some flexibility on that. And then lastly, when you are sending us your pleadings, evidence, and all of that, please take the time to name the documents so that they can be more easily located by us during the proceedings. So something that identifies the document at a minimum would be a huge help.
Yes, and I'll echo that. I know everyone's got their learning curve, and the judiciary is no exception. And we're trying to get up to speed as quickly as y'all are. So I can tell you for myself, as soon as I master the Google Drive and how to do it and its functionality, and Judge Diaz and Judge Alvarado have been so gracious to kind of help me come up to speed, I will probably switch over to that because functionally it makes more sense. I also have to bring my court reporter up to speed as well. So we are all doing different learning curves. And so this week, you know, the week of April 6th, I may be asking for emails. The week of April 13th, I may be sending the invitation with a Google Drive to dump it that way. But I will, and I think everyone will be working to try to make this as painless as possible and as accessible as possible for everyone, for our litigants, for our self-represented litigants, for the witnesses and each other. So we're trying, but it's going to take some time. All right, so let me go to sample Zoom admonishments, just what a sampling of what you may see from different courts. You may see witnesses being asked not to have anything in their hand or not to have anything in their space or to identify what they have or what they're looking at on their computers and their phones. You may have explicit admonishments not to research anything unless they're given permission to do so. Again, maybe you're going to be asked, or opposing counsel may ask your client to kind of show their hands, show their space, show their lap. There's a question about sharing the exhibits that have not been agreed to. And maybe the judge may need to see them in order to make the ruling with the share screen tool. So just be cautious. These hearings are going to go a lot slower. As you can tell, or maybe you've noticed already in some of the hearings that you've done, there is a delay in when you object or when you try to begin your argument. There's a slight delay before Zoom will pick up a different voice. So be mindful of that.
May I add to that, Judge?
Yeah.
On the issue of exhibits that have not been agreed upon in advance, the chat function allows you to privately chat with someone. And so one of the things that's been suggested for exhibits that have not been agreed upon that you don't want to provide to the judge in advance for some reason, when it is appropriate in the hearing and you want to present that exhibit, you can go into the private chat function and you'll see on the bottom right, you should see a little page and the word file. If you click on that file, you can upload your document, your exhibit, privately share it with opposing counsel, state for the record that you are, for purposes of the record, sharing whatever exhibit with opposing counsel through the private chat function for review and objection, if any. And then at that point, if the judge still needs to see it to make a ruling, you can then share it with the judge as well. But that's one way that you can share it with opposing counsel before sharing it with the judge.
And if you look at your chat, I just shared the Zoom outline PDF with everyone. If you wanted to share a document with your opposing counsel, you would just identify, instead of to everyone, you would put like a private chat, and then you should be able to upload it. So hopefully that helps demonstrate that just a little bit. And miscellaneous things. If you're going to need it, so I know we are relying on our bar and our attorneys to do a lot more conferring before you come down to the courthouse for your temporary orders, temporary injunctions, motions to compel, well, mostly the evidentiary things. To the extent that you're not able to reach agreements and say, you know, defendants 1 through 10 are agreed to and admitted, plaintiffs 1 through 5 are agreed to and admitted, and those are all the exhibits that we have. If you're going to have an evidentiary fight, an exhibit fight, it probably makes a lot of sense for you to make that announcement to the court ahead of time. And even for a temporary orders hearing, if you need to have, you know, a 10, 15-minute pretrial hearing just so you can get through the evidence objections and make your presentation during the temporary orders hearing smoother, that may be something worth exploring, either exploring during your conference with the opposing counsel or exploring with the court as your hearing is about to get started. Are there questions now? And okay, if there's no questions, we're at 5:40. It's been about 30 minutes. Judge Diaz, would you mind kind of giving us the highlights of what was observed during your mock trial?
Sure.
And of course, any lessons learned from the remote hearings that you've already had that you'd like to share?
Sure. I'll start with the mock trial. We had a few planned faux pas and then a few actual faux pas. So it was a good learning experience for us all. We had Mark Unger's internet connectivity kept going out. He kept getting frozen and kicked out of the conference. So one of the recommendations he had was to have a backup plan in place for your hearings. So if you're reliant upon your wireless connection, you may want to have a hotspot like on your phone. He was able to use his phone hotspot to get back into the conference. So if the internet goes down, have a backup for that. He had multiple devices as backups too. He had a tablet and his phone. So I really recommend considering having some sort of a backup for that. Let's see. One of the recommendations was as you're preparing to participate in your hearings, and if you only have one screen or even if you have 2 screens, it can get really busy. So to close everything out that you're not going to need and just have open your exhibits and the things that you need for that case, it'll help smooth or make things go more smoothly. With the breakout room, I sent our counsel and client into a breakout room at one point, and they didn't know how to get back in or what they should do next. So when you're sent to a breakout room, us as judges will have to give you these instructions, but you have 2 options to either leave the meeting, I think, or to rejoin the meeting. So be sure that if you're sent to a breakout room, you don't leave it, you instead rejoin, just as if you would step outside the courtroom and we would wait for you to finish conferring with your client and then you'd come back in. We'd expect you to do that.
Can I ask you a question about that, Judge? In a mediation that I was in today, we had breakout rooms, and then there was a function where when we were ready to talk with the mediator or ready for him to come back in, we would click a button. Is that something that is possible as well?
I'd have to go back and test it myself. If it is, I would love that as a notification that you're ready to come back instead of you just joining again. So I'll have to look into that a little bit more. Thanks for bringing that up. Any questions about any of that so far?
I will, we do have a question from Ms. Guerra. If someone gets dropped, how do they get back in? Does the court stop the hearing? And so Judge Diaz, since that happened, do you want to address that?
Sure. That's what we did. We stopped the record and waited a little bit to see if he would get back on, and then he got back on. One of the issues my court reporter brought up is that if my court reporter were kicked off, I may not notice that, and that could be a potential issue. So I think maybe collectively, as Judge Alvarez said, it's really hard to manage all of the things at once for all of us. But if we could all try to at least make sure that the court reporter is still on the conference, that would be great. One feature that I learned is that you can actually scroll over someone's box, and in the ellipses, click on that, and you can see the option, you should be able to see the option of pin video. So if you wanted to pin like the court reporter's video to the top or a particular person's video so that you're always seeing that regardless of who is speaking, you have that option. So anyways, to answer your question, it's just like regular court. We just take a break, go off the record, and try to remedy the situation.
And I will say something that Judge Miskell shared is that for whatever reason during one of her hearings, she was actually kicked off. Her internet connection went down, it got spotty. I can tell you during the course of some of these Q&As and during the course of some of the remote hearings and the mock hearings, I have gotten a note, and I've not moved. I'm here in my kitchen island. This is my space. But the internet connection will just, and I've got Google Fiber, it'll just come and go. Well, Judge Miskell was dropped, and thankfully she was able to text her court coordinator, who was also in the hearing, and let everyone know to just stand by, that she was trying to reconnect to her own meeting. But if that happens, just stand by. I assure you, if the judge gets kicked off of the hearing, they are scrambling to get back in. And likewise, the same grace and patience will be extended if a litigant or a witness gets kicked off the hearing, or the connection drops, or they accidentally press end or leave meeting when they meant to, press mute. I mean, who knows? So it's going to happen. You're going to have the tech issues, and we're just going to try to all work together to get through them as quickly and as patiently as we can. Here's a question regarding a pro se. So this is something that's been coming up, and everybody can go to the chat to read the question. The question generally is a pro se order to appear. Can we compel attendance? And I would assume that the same question would be with the adverse witnesses, or the witnesses that you don't have any control over, that you're trying to get to appear to a place certain. In this virtual courtroom that we have set up, I don't know if the contempt rules apply. I think that's probably going to be an issue that is going to be, that's going to have to wait until we get back into the live courtrooms and we can give a space and an address certain by which we could actually authorize a capias. I don't know. I don't know, Judge Diaz, if you have different thoughts on that, but
I think you're right about that. And I think the question was also specific to the Zoom hearing. And when we send the email out with the credentials, it has the link for the Zoom hearing through this medium, but then it also has phone numbers that you can call into the proceeding. So it's not perfect, and it's certainly something that we're exploring in terms of how we can improve that process. But at a minimum, you're not just ordered to appear to the Zoom proceeding, you're at least ordered to call in. And so we'll have to figure out all of those details, but most people should be able to access a phone to call in. But I think Judge Alvarez is right that this is going to be a developing issue, and I don't know that many of us are going to be holding it against people if they don't have the ability to Zoom in or to call in. I think we'll have to address that on a case-by-case basis.
And also, please be aware that our jails are, trying to comply with only the worst of the worst staying in the jail in order to try to do what they can to control the COVID spread for the folks that are incarcerated. So it may not be that someone who doesn't appear, a paramour who doesn't appear at a temporary orders hearing is going to be the person that the sheriff wants to be taking up a jail spot for the next, 4 to 6 weeks. So, so those are issues that we're going to have to work through. I know that's not a real answer, but it's really hard. I would imagine it'd be really hard to get someone held in contempt or a capias issued for a virtual courtroom. So if we can, Dr. Trevino, Ms. Vance, I know y'all were in a lengthy protective order hearing with Judge Jimenez, and I was wondering if we could take a few minutes and put you both on the spot to share some of your experiences, some of your lessons learned with the rest of us in order to kind of help everyone get up the learning curve just a little bit faster.
Well, one of the best tips I got was from Dr. Trevino, who told me not to make faces because I was making faces and I was right on the camera, and I was not as conscious of that as I should have been. And so I was very, very grateful for that. The other comment that I got from Dr. Trevino was that the placement of the computer was important because I had so much junk on the walls behind me that it was distracting for a witness. So this morning I moved the camera, and I was totally not even thinking about things like that. So I'm very grateful to keep grumpy faces to myself and be in front of a beige screen. The other tip that we had was before we did the microphone, the hearing was the other lawyer in the hearing was Lee Cutter, and she had a law student, I think, or maybe a paralegal, who had a great tip, and that was that because there was so many people involved in difficulty with Craig Carter hearing what everybody was saying, she had us press the space bar, and that seemed to make it easier for Craig to hear what other people were saying. So if you don't want to spend the $40 on the microphone, maybe that would be helpful.
That's a good suggestion.
Yeah, I'm sure Dr. Trevino has other much more important things to say than me.
I'm struggling. I was struggling to take the audio off. I kept forgetting when I was asked a question to turn the audio off, or then turn the audio on, and then just, and so there was the first time yesterday that I was testifying, and it was hard to wait. You have to wait longer than usual for the attorney to object. And it was hard to do that because the lag time is just hard to get used to for me. So I had that as a little bit of a awareness that I didn't have awareness of that. Also, I found I was on as a witness, but somebody else was coming in after me as a witness, and she kind of has, I think, less experience. Like most of my clients have less experience in this than I've developed over the last week, and she was kind of bumbling a little bit, she couldn't find the camera. Judge was so patient trying to help her. Then she forgot to turn off the camera, and then people came in, forgot to turn off the sound, and people were coming in to help her, and they were whispering about, can you do this? Can you do this? And it was to be expected, and it was all it went fine. It was not a big deal. But I think that it made me feel better that it's okay to mess up a little bit, because I'm sitting here freezing. I'm trying not to move, and I can't really see the screen, and I don't want to get, I'm feeling awkward that I feel like I'm on the camera all the time. So there were a bunch of mistakes that this new lady, RN, made that were just sort of calming, because I know we're going to make them.
And if I could piggyback on that just really quickly, this is new to us, and we've kind of been scrambling to learn it over the last 2 weeks. For the self-represented litigants, for your clients, witnesses from the police department, from CPS, from school counselors, counselors in general, they have not been trying to learn this and study on this. They've been trying to maintain their business. They've been trying to figure out doing their agency work with a skeleton crew. They've been trying to navigate just as many news reports as we have regarding the state of our medical crisis. So do probably a little bit more prep with your witnesses than you would ordinarily do. Maybe do a Zoom conference so they're familiar with the technology. Maybe talk to them about the angle of their camera on their computer, right? You don't want it like this. Nobody can see that. You don't want it like that. That's not appropriate either. You know, you just things that we're trying to navigate and we're trying to learn, and we've had the 2-week span to do. A case that's set in a week or 3 weeks, just know that they haven't had the time that we've had, and they may need a little bit more hand-holding just with the technology, not even dealing with the anxieties of the specific case or their testimony. Judge Diaz?
Yes, there was a lot to cover there. Let's see. In the comments, there's some questions about from Ida regarding who's to notify the pro ses. Did you just cover that? To notify them? Basically, right now, to answer this, this is an all hands on deck operation, and we love our local bar, and we're gonna lean on you guys to help us all catch everyone up to speed. So as judges, we're working on webinars, CLEs, whatever we can do, trainings like this. We're in communications with the Office of Court Administration, who's helping us figure out ways to better train and catch pro ses up to speed. So we're going to do our part, but we respectfully ask that if you do have a pro se on the other side and you have the ability to talk them through how this works, it would help all of us. It would help the proceedings go a lot more smoothly, but it's certainly not your job or your duty, but it's something that would be very helpful. And then to Heather Holden's question, will Zoom initials be given by the judge? Yes. So the judge who receives the assignment is the one who generates the Zoom meeting and will send the credentials out either personally or through staff to the parties involved. The YouTube channel, I'm not sure how to answer your question about notices to pro se parties, informing them of the YouTube channel to tune into. I think we're still working on those details. Judge Alvarez, do you know the answer to that? What we're requiring to be included in the notices to the parties?
So the notices, when you're setting a hearing, and I think a lot of you already have gone through the operating procedure, it identifies what needs to be on the new notice setting a virtual hearing. We need email addresses. I see the Family Law Bar Association Facebook page. There was some concern about what do we do if the pro se doesn't reveal the email address. I don't know if there's an answer to that just yet, but the email addresses are what the presiding court is going to give to the judge that is going to be presiding over your particular hearing. And that's how the notice for the hearing will be given. So that's going to be something that we're going to have to work through. With regards to the notice of the presiding court YouTube channel, just generally, I think that's going to be posted on the SAVA website and on the Bexar County Civil District Court's website. And they, just like you, can go to that website and find the YouTube channel for presiding court if they want to watch the live stream of the docket call. I don't know if the question was regarding individual courts' YouTube channels. Not surprisingly, different judges are doing different things. I'm not going to be live streaming my hearings. I'm going to provide the Zoom address for the hearing that day, and people can go to the YouTube channel, see the address, and come into the courtroom, if you will, if they want. I think Judge Diaz, you're doing the same thing because you helped me get mine set up.
I am.
So I don't know which of our Bear County judges are going to be streaming to their YouTube channel. I think several of us are just putting the address and then having them come into the courtroom, spectators come into the courtroom if they want to observe. I think Judge Gonzalez, to the extent that people can still go to the courtroom, has her courtroom open and has a monitor there. And so her open courts, her fulfillment of the open courts provision is that you can physically go to her courtroom and see the Zoom hearing on the screen that's in her courtroom. I'm not sure how many other judges are going to be doing that. But there are some questions about monitoring court, and we have been really lucky to get Miss Lisa Dossman with us after hours. So Miss Dossman, can I turn the floor over to you and kind of make your answers to everyone that you've already put into the chat, just in case it was missed, regarding monitoring court? Ms. Dossman, do I see you? No, maybe she was disconnected.
No,
Oh, there you are.
I'm here, Judge.
Okay.
I just had to move to a different room because I was in my bedroom.
Thank you, and I'm sorry to put you on the spot. I
No,
just,
that's okay.
okay.
Monitoring court is going to have their own procedures, very similar to presiding, and we have our procedures on the Bear County District Clerk's website as well. So what we're thinking also of doing is having a YouTube channel, and you'll have to put on the fiat and your order setting, all the information, as well as what presiding is asking for. And everything's going to be remotely.
So have we gone through the questions on the chat? I'm trying to follow along.
There's one more I was just typing an answer to. I can just say it though. Is there some way to make sure witnesses are not watching? The only way we can guarantee 100% that a witness is not watching is by requiring every participant to identify themselves visually. And obviously not everyone has the ability to do that. I don't believe that it's proper, in my opinion, to require everyone to use the video function. I think there's one other county at least that is requiring that for all participants to identify themselves that way. The way that we can, one of the reasons why we're not just streaming everything on YouTube, we're putting a link in our comments on YouTube for people to then come to the Zoom conference, so we have some control over who is in the room. As judges, we have to admit people into the courtroom from the waiting room, or at least most of our settings are set to that. So at a minimum, if we see someone in the waiting room and we admit them, we can ask them to identify themselves. We can't force them to do it. We can ask them if they're a witness in this case. They could not respond. But that's certainly something we're going to have to deal with, and we're going to, assuming that people are properly identified, we'll rely on lawyers to help us make sure that we don't have witnesses in the courtroom. But it is going to be an issue. We're just going to have to do the best we can with the technology right now.
And I will add just a little bit to that, and maybe it's because of what I did before. I am particularly sensitive to people, especially if it's a abuse, child protective order, kind of abuse, neglect situation. I think not identifying yourself when asked by the court is disruptive. And I'm still doing the research on open courts and what the boundaries are, especially given this era. But if we're having a protective order hearing and we've got folks who no one can identify, who aren't necessarily witnesses, and who are not answering the questions of the court, I'm probably going to put them back in the waiting room. I would not let somebody come into my courtroom and wear a mask. I would not let somebody come into my courtroom and not be responsive to the authority of the court in person. and I have no expectation of doing that virtually. So again, this is new, and we're all trying to learn, we're all trying to study, and we're all trying to do it simultaneously. So if I'm wrong, then of course we'll have to make adjustments. But I think, especially when we're dealing with protective orders, child abuse cases, 262 hearings, there's a lot going on to have anonymous, unidentified, uncooperative, unresponsive spectators in a hearing. So I'm still doing my research on that, but that's where I'm at. And again, just so you can have an appreciation of all the things that the courts are trying to consider and balance. So I see the default judgment question. There were some procedures, and I just don't have them up, so I don't want to speak out of turn. And I think, Ms. Irie, you had asked about that. When the procedures regarding April 6th were put out, there was a section regarding agreed orders and default orders. So if I could just reference you back to that to get the answer to your questions, because I haven't memorized it. I'm showing some lack of study on my part.
I said the same thing.
Okay, okay, good. All right, are there any other questions? I hope these are helpful. I really want to make sure that we are helping each other. And on that note, I forgot to mention that the Bexar County Women's Bar Association is hosting a seminar. Judge Diaz and I, and Judge Alvarado and Judge Arteaga, I believe, are the panelists. And Judge Poza will also be speaking first to kind of answer the question, what can we expect from presiding court come Monday, April 6th? So please look on their Facebook page, look on their website. The credentials for the Zoom meeting are there. I think they've got enough licenses to let 300 people come into that virtual seminar. And then Judge Diaz is working with Saba to do another one. Judge Diaz, I'll let you speak about it.
Sure. We are working on, with Saba, putting together a webinar after the first week of this new presiding system beginning Monday. So look for announcements for that. We're hoping to have it scheduled for the week after next. Tips and tricks, perhaps a mock trial. We're not sure if we're going to do that yet, but basically it'll be a summation of everything we've learned so far. So keep an eye out for that. And then I know it's 6:06, so I know we want to be mindful of everyone's time, but I have one last really important thing I wanted to cover really quickly, and that is your exhibits. We need you guys to keep track of which exhibits are being admitted and which ones have been offered but are not admitted. Normally at the end of the hearing, we'll ask you if you agree to withdraw. And if you do, then that's great. But if you don't agree to withdraw all exhibits, it's going to be your responsibility to make sure that those exhibits make it into the record. So at the conclusion of your hearing, you'll be asked to email or otherwise provide your exhibits to the court reporter in 2 folders. One will be exhibits that were admitted. One will be exhibits offered but not admitted. If you have a hearing that is going to last more than 1 day, the court reporters need to know what day those exhibits were offered. So my recommendation would be, if you have a long proceeding, keep separate folders where at the end of the day you're dropping in the folder after that day and drop in the exhibits that were admitted and offered but not, and then do the same the next day. That's going to be really important for y'all as these proceedings.
Thank you. So before we sign off, are there any other questions or any other information to share? Ideas to share with your colleagues, with us? Mark? I was looking at you.
Yeah, hi. It occurs to me on this exhibit issue that perhaps we could brainstorm a standardized naming construction type of thing, to where we recommend to people, let's call exhibits by this, this, and this. So every firm, attorney, court reporter will maybe use different ways to call it, like plaintiff's exhibit 1 or petitioner's exhibit 2 or P1 or something like that. And then have a date, 4.2.20 at the end of it, maybe some identifier. And so we can think about what fields we want to do, and then try and recommend that people call things similar with similar names so that there's some uniformity. This is the biggest problem, has been the biggest problem in the past with e-filing in particular. There's a lack of uniformity, a lack of similarity. And so that may be something to put on a brainstorming list, along with many other practice tips that various people have found. And so what we're looking for is best practices, and then some consensus, and hopefully that drives sort of a wave of towards everybody doing things similarly. And so I see a chat example, 2020. So there's two schools of thought in naming construction conversations that we have in seminars a lot of times. One is that you put the date first, and then you put something along these lines. I like this because it identifies the party, it identifies the case, and it identifies the cause number. And in this particular example, Judge, you have the date first. A lot of firms do it this way. I think more larger firms and small firms, because then you can see the order, the most recent, naturally. I do it the other way, where I have the date at the end, and I'm using the name, but that's just because my brain works in a certain way. So the conversation of trying to come to consensus about naming constructions across attorneys, judges, and court reporters would probably drive that conversation to a center circle where you've got these overlapping parts, and help, of course, completely shifting the burden onto the attorneys. And offline, I'll talk about, with anyone about the problems that have happened in e-filing on that issue. Doesn't solve the problem, because let's say you have 254 counties, and let's say you have double that in judges if you have district county. Then let's say in big counties you've got many more. But think about, you've got 80,000 practicing attorneys. So which one has the greater chance of human error in doing things differently? So if we can create from the top down sort of some possible common sense solutions and then recommend them, maybe we can drive that train a little bit.
I'll bring that up at our next meeting.
Yeah.
Yes. Thank you. That's a good suggestion, and that would be helpful to me and to my court reporter. And I was looking through really quick. I forgot Judge Flores from Eagle Pass had joined us, and I think she might have gotten off already, but I think she plans to join us tomorrow as well. I'm sorry that I didn't recognize her before, but for those who practice in her county, or for those who practice in other counties besides Bexar, this is an invitation that's open. Judge Flores was with us yesterday, and again, I suspect she'll be with us tomorrow. So please bring questions and best practices that we can all adopt and incorporate. And thank you, Mark, for that. Yes, ma'am. I'm sorry.
Judge, really quick question. Actually, it's not a quick question. What are we doing with, are interpreters available still? Are they going to be assigned to a room if we say that we need one?
Yes.
I've not gone into that yet. Have you?
Not on the remote hearings for the essential the essential hearings, I haven't. But I do think that they will be available. And again, starting April 6th, I'm not sure how far down the docket we are going to get on the non-essential hearings as we come up to speed, everybody, on this. So the docket is open, it's capped, and it's very clear that the essential hearings are going to take priority. But there is, and I heard this with Judge Miskell and Judge Ferguson, there is a function on Zoom for interpretation. And there are remote court interpreters that are ready to be brought into the Zoom hearing. But I can't tell you now, because I haven't studied it enough, logistically how that execution is going to work. But it is available, and that is actually something that is being requested by our presiding judge on your time announcement, on your notice, to identify what it is if you do need an interpreter. So again, I think that was captured within the April 6th operating plan. I know it's a lot and I know it was dense, but just go through it, and I think you'll see that that's part of what you need to let us know about ahead of time, is if you're going to need an interpreter. All right, then with that, unless there's something burning, if you'd like to be brought in tomorrow, please email me. And I had said that before, and I didn't tell anybody my email address. So it's marylou.alvarez@bear.org. But send me an email. Just let me know that you want to be invited, and I will capture all of the requests and send it in the invite for tomorrow's Q&A. And also feel free to share. So if you know some of your colleagues are a little hesitant, or some of your colleagues are not practicing as much as you are, or would like the opportunity to come and ask questions, send the invite to them. It's not a closed session. So thank you all so much. Judge Diaz, thank you. Thank you. Thank you. I know you've got a lot on your plate for co-hosting. And we'll see y'all, I guess, at the next Zoom hearing or Zoom Q&A. All right, folks. Thank you.